Michelle Tedford. I work here at the University of Dayton. Thanks so much for coming. I just wanted to say real quickly before we start that if you are a foster parent in Montgomery County and you would like to receive credit for tonight's event, Kevin, can you raise your hand? Just stop over there, sign up, and get a form that you can show to your worker to get an hour's worth of credit for this evening. Thank you. And I would like to introduce Dean Strauss, who is here to open our event this evening. Thank you.
Thank you, Michelle, and thanks very much to Michelle, whose inspiration this event was tonight, and who really put the legwork into organizing this event. So, as the Dean here at University of Dayton School of Law, I'd like to welcome you all to this event. A debate, a friendly debate, I believe, between Jeff Rezabek and Helen Wallace. And, you know, I really feel very privileged to really be here to introduce this event tonight. I think that if there's anything that's central to our mission here at the University of Dayton School of Law, it's hosting this type of event. It's really local democracy at its best as we face this choice for a juvenile court judge right here in Dayton, and obviously this position. We just, I guess, all experienced the choice for the next Supreme Court justice, which of course got extremely heated and has tremendous implications for all of us in the country. But for many people, this decision is going to be even more momentous for people who go before and have their whole futures decided by this court, and that's what American local democracy is really all about. So I'm very privileged to be here and to be a part of this event tonight. I'd like to thank our co-sponsors, the University of Dayton Foster Parents Resource Group, which offers fellowships, resources, and advocacy towards a foster family-friendly campus. The Montgomery County Foster Parents Advisory Board, which advocates for communication, consistency, and a team care approach for children in Montgomery County. And the University of Dayton Vote Everywhere program, a nonpartisan student-led civic engagement movement. So thanks very much to all of our co-sponsors tonight. And finally, a big thank you to Jeff Ireland, tonight's moderator, who has been a great friend of the law school. He's on my Dean's Advisory Council and has been a friend of the law schools and the universities for many years. So thank you, Jeff, as well. And with that, I will turn it over to Jeff to introduce our candidates and move on with tonight's debate. Thank you.
Thank you very much. Well, I want to thank all of you who are with us in person for attending this event, and I also understand there's a live streaming of this on Facebook, so that's quite exciting. So all of you who are out there watching on Facebook, welcome to you as well. The format and the rules for this evening are pretty simple. Our conversation this evening will begin with a 2-minute opening statement from each candidate. Our representatives from Vote Everywhere have conducted a coin toss, and as a result of that coin toss, Jeff will be proceeding first with his opening statement, followed by Helen. We will then go into questions compiled by a panel of individuals who work with child welfare and alternate between the which candidate answers the question first. Each candidate will have 2 minutes to answer, with an optional 1 minute for rebuttal. And then we have timekeepers who are sitting right in front of us, who will signal when there is 30 seconds left and then 10 seconds left. After we've concluded with these prepared questions, we will have time for a few questions from our audience. So you can submit your questions. Please signal.
Submit them over here, please. And volunteers, raise your hands, please, so they know. So wave at one of these individuals and they will get you a note card.
But our last question will be accepted, I think, with 30 minutes to go. And if we really get desperate, I will ask questions, but I will tell everyone I have never appeared in juvenile court. We will be following lines of questioning that abide by the Ohio Code of Judicial Conduct, which means we will not be asking questions about cases either before the court or likely to be before the court, nor questions requiring the candidates to say how they would vote or decide an issue in a specific matter, in a specific situation. And then we will conclude with closing statements. And please, I do think this is important, kind of hold your applause to the end. I think that's the fairest thing for all of us, and it's also calculated to make sure that we maximize the amount of time that we have together. So with that, Jeff Rezabek, proceed.
I just want to introduce myself. I'm Judge Jeff Rezabek. I am the current judge of Montgomery County Juvenile Court. I got appointed to that in July of this year. But I would just like to take you back a little bit. I'm originally from Western New York, Buffalo. I came here to the University of Dayton, graduated my undergrad in 1991. Came back, I started a master's in psychology, as well as then went into law school here. So I graduated in 97 from law school here at the University of Dayton. Began my law practice with an attorney by the name of Charles Smiley. And what happened, we then began a love affair with really juvenile court. And it was simply by accident. I ended up, while I was waiting for the Ohio bar results, I ended up answering an ad for a program called CASA, which is Court Appointed Special Advocate. And I thought, well, the attorney's got to give back to the community, a little service. I've done a lot of service with children back in Western New York, so I thought this would be a perfect opportunity. Never knew it really would ultimately grow into a passion, and sitting here today as your judge. I then began the legal career, the criminal defense, a lot of juvenile court. In fact, many people joked about that I already had an office in juvenile court. Now I do. But then through this whole process of 20 plus years as guardian ad litem and as an attorney in juvenile court, I was asked to run for the State House, and that was a great experience. I served two terms in the State House. I left when I got appointed, but one of the things that I did at the State House, I continued to have that passion for juvenile law and looking at all the things that I have done at the State House for children, foster families, as well as working on the Justice Committee and our sentencing and trying to change those laws. I believe with all of that experience in me as serving as a substitute magistrate and Dayton Municipal, that judicial experience is very important, and I would ask that you guys continue to look at that when you guys go to the voting booth. Thank you very much.
Thank you, Jeff. Helen Wallace?
Thank you. Thanks everybody for being here. This is such a great evening and a great forum, and I'm looking forward to talking with you about the issues that you all care about. My name is Helen Wallace, and I am running for Montgomery County Juvenile Court Judge. I am running to replace Nick Coons, who unfortunately passed away in May of this year. I grew up in Cincinnati. I went to Walnut Hills High School, and I graduated high school in 1991. Walnut Hills is a source of great pride for me because they are the #1 high school in the state of Ohio, and they have been for decades. I got a great education there. After graduating from Walnut, I went to the University of Cincinnati, and I did the very practical degree of international affairs. So my junior year of college, I had decided to go to law school, and that's when I declared my major. I put it off as long as possible, but I knew I wanted to go to law school. So I graduated from GW Law School. I was lucky enough to live in Foggy Bottom and walk to the Supreme Court every morning down the mall and walk back, and also got a fantastic legal education there. I came back to Cincinnati, where I married my lovely husband, Adam. We've been married for nearly 20 years, and I started doing civil litigation for a Cincinnati firm. About 2.5 years into my civil litigation, I was not feeling satisfied. I was not feeling that I was accomplishing anything. So I moved up to Montgomery County, joined the prosecutor's office, and since early 2002, I have worked in juvenile court as a prosecutor, a defense attorney, a custody attorney, and a guardian ad litem. So I've had the pleasure and the privilege of working with kids and making a difference in their lives for over 17 years. I have a private legal practice that I've run successfully for 13 years, so I also have a lot of business experience, which helps me budget and make things very efficient. Thank you for your time.
Thank you both for your opening statements. So the first question goes to Jeff.
Yes.
Children of parents addicted to opiates are flooding into the state's beleaguered child protection system. What do you see as the role of Montgomery County Juvenile Court in addressing the needs of these children and their families?
Thank you for that question, and it's a truly important question. In fact, it goes back to not just the opiate issue, but when we had an issue with crack cocaine. Many of the things that have happened in our community is juvenile court is going to know when things happen or things are starting to change. We missed it when we had the crack epidemic. Juvenile court missed it again. In 2007 and 2008, we started to see one or two parents all of a sudden are overdosing on heroin, or we had a baby at Children's Hospital, and we didn't pick it up. One of the things that I want to do is work with juvenile court and continue to devise plans in which when we see these things tick up, we need to respond much more quickly. The opioid issue has plagued our foster care system. We do not have enough homes. We need to work better with, the court needs to continue to cooperate and collaborate with Children's Services. Was one of the things to come out with new ways and new initiatives of how to deal with these types of situations. One of the things that we also need to do is engage our faith-based community. There are a number of things that in the House budget, we were able to 2 years ago get the extension, most people know as the extension of foster care to 21. In essence, that is a balance of trying to get these kids who are coming out of foster care into a positive experience, and that's usually used through the faith-based community. The other thing that we need to continue to work on, and this is what I did in House Bill 126, is work with kinship individuals. And one of the things that we need to do is make sure they have the assets. If we have family that are, and we know by the data that kids do thrive better in a family situation, then if we can get them in their home back into a safe environment with their family, we're doing good things. So we need to continue to work on programs that look at those issues. That's how you really address this issue here in Montgomery County.
We are very fortunate here in Montgomery County to have a very innovative juvenile court. Juvenile court has started a family treatment court specifically to address the opioid epidemic. The family treatment court runs after getting a $2.1 million grant that the court got on its own to keep parents unified with their children. It's a fantastic program. It's a new program, so we don't have statistics yet on how it works, but I can tell you from my experience that it's very successful. It's basically an intensive probation type program, except a parent doesn't have to be charged with a crime. Their child does not have to be found abused, neglected, or dependent. Children's Services could make a referral. The parent themselves could reach out for help. And what the court does is monitor their progress. The court will have a parent, if the parent needs to come in once a week to be held accountable. Are they going to draw clean? Are they going to test negative for drugs, or are they going to be positive? And with the progress that the parent makes, the more parenting time they get with the child. And that bond is never broken between the parents. So it's great for consistency purposes. And it really works well because the parents are highly motivated. If they come into that docket, they are motivated to stay in their children's lives. So I would like to see programs like that enlarged. Right now, that docket can only serve about 75 parents and about 170 children, but it can grow, and we can innovate other type programs that can help children and keep things in their best interest. Thank you.
Good job.
So the next question goes back to Helen, question number 2. It currently takes upwards of a year for the juvenile court to rule on an objection after a magistrate has determined that permanent custody of a child should be awarded to the state. What would you do to manage your courtroom and docket to expedite permanency of the child? Could you commit to 90 days to rule on objections? And should a permanent custody ruling bring with it a change in the visitation order?
I have a better idea than committing to a 90-day time frame. I think that judges should hear the permanent custody cases themselves. Right now, the magistrates hear them. And then people object to the permanent custody decision, a transcript has to be done, and then it goes to the judge for review. If judges heard the initial permanent custody motion, there wouldn't be need for an objection. Somebody could still appeal it to the Court of Appeals, but it would be out of juvenile court. And the Court of Appeals also has an interesting order for, not interesting, a great order. For permanent custody hearings, the Court of Appeals orders right away that the transcript be done expeditiously, as fast as possible, because a child's life is hanging in the balance. So we need to make time on the judge's dockets to hear these cases. I believe that we can do it. I believe that if the voters vote me into office, Judge Capizzi and I can manage our dockets so that we're the ones hearing the permanent custody cases. Now, the downside of that, the reason that hasn't been done before, is the magistrates say, well, we're the ones that have had the case sometimes for 2 years. We know the history of the parents, of the caseworkers, and a judge does not. Well, Judge Capizzi and I are both very experienced in juvenile court, and I think we can take the cliff notes and read the case file and have an adequate understanding of what needs to be done. It's also beneficial because it'll be a fresh set of eyes, a fresh set of objective eyes that doesn't have maybe, even if you try not to have bias as a magistrate and do your very best, sometimes history can still seep in. So by having those cases go to the judges, you are assured that it's an objective decision. So vote me in and I will do that. Thank you.
We're already starting to do that in juvenile court since I've been there. One of the things that has happened is I sat in court many, many times as the guardian ad litem for a child. And we sat in front of a magistrate. And it takes over a year to get a transcript, and then these filing the briefs and doing all that. While one thing is happening, a young child doesn't have permanency. And we've asked, years ago, when we had Judge Murphy on the bench, before Judge Kuntz became the head judge, we would send over court reporters inside the room so that they could actually type it right then, so you didn't have to wait for the transcript, because that's the bulk of what the issue is. Since that time, we've not had it. Since being appointed in in July of this year, that was one of the first things I said to the magistrates. I want to get some of these permanent custody cases. We need to have it going in the right direction. We can't have these kids sitting and languishing in foster care. One of the things you talked about, one part of the questions was 90 days. If you're talking 90 days from getting the final brief in, I think it should be less than that. You should already be working on your brief, or at least reading through many of the documents, the transcript and all that, early on. I think that's what can happen. That 90 days, if it's 90 days from the decision, just can't happen because you have to get that transcript. The only other thing to really do to try and speed it up is to look at having our court reporters actually sit in the magistrate's room and do that right away. I've encouraged our staff to do that. That decision is up to Judge Capizzi at this point. He's the administrative judge. I would encourage him to continue to do that. We want to get these cases through. You don't want them languishing. We have 239 children sitting on foster care that have been in foster care beyond 2 years after their PC. That's unconscionable. We need to continue to work it. I'm already working on what's called a permanency docket to try and get that under control, and I've done this since July.
I just realized that I'm supposed to give them each a minute for rebuttal, which I have failed to do on the first two. So we're going to start this on the third question. I knew that if there's anybody who could mess this up, it was me. So you two are doing great.
You're doing great.
The third question is directed to you, Jeff. The Federal Family First Prevention Services Act was signed into law in February 2018 and will come into force in Ohio in January of 2019. The provision regarding placement of foster children in group homes has the potential to create a crisis situation where children needing group home care no longer have options for a placement longer than 2 weeks. How will you work with Montgomery County Children's Services to ensure children are in placements that not only follow the rules, but also fulfill their needs?
Sure. With regard to the Family First Act, Prevention Services Act, We already believe that the state of Ohio is going to ask for a waiver on that, which would give the state another year to 2 years, depending on how they fill out the waiver. The state has already said they only want about a year to really work on this. The biggest concern is there are a lot of new regulations that would affect group homes as well as many other areas. I know the question focuses on group homes. One of the things that you have to have, and just as an added requirement, would be to have a nurse 24/7. Okay, if you just look at that, there's only probably one group home in the Southwest Ohio that could even qualify under just that little standard. And so it would change. Even our Nicholas residential home service would not qualify. Although we're building a new Nicholas facility, and actually we're taking in a number of children's services kids, and we would have a nurse in there, so we would qualify. What you really have to do is focus in on, again, probably not placing kids in those group homes, because you want them permanency. We know, again, from many studies, the number of kids, the number of times a child moves, you end up having more and more issues of attachment, of behavior issues. We want to continue to make sure that that doesn't happen. Easiest thing to do is really work early on before you have to place a child at a group home, to work with their family, other kinship individuals, and try and get the child's placed back at the home. If you're able to do that, that's great. That's how that placement will work. If you do have to go in a foster home, then it is really trying to work with the community and the faith-based community to increase the number of foster parents that we have in our system, so that those kids can be in a loving, stable home. Even though, because a lot of the foster kids that I've represented as guardian ad litem, they really get attached to those homes and they want to go back, and I think that's a way to work out. Helen?
Thank you. Unfortunately, the way that a child ends up in a group home is because he cannot be placed in a foster home, or there are issues with the foster home. So group homes are often the last resort for children. A lot of our older kids, 14, 15 years old, who have multiple delinquencies or assaults, things that make them violent, would not be suitable for a foster home because there might be other children in that home, or a multitude of reasons that we can't get into. But the children in those group homes need the services that the Family First Prevention Act provides. It details that children in those homes need mental health services, they need drug and alcohol substance abuse services, they certainly do need a nurse. Terrible things happen in these group homes, terrible. Girls and boys are trafficked out of these group homes. There are assaults on each other, on other children in these group homes. The act is going to cost money and be difficult to comply with. It is challenging, but I don't think that it's all bad. The question is, where's the money going to come from? And that's always the question. The act provides that there's going to be these competitive $8 million grants, but it doesn't really detail how that would happen and what competitive means. Is each county going to get $8 million? Is each state going to get $8 million? What are we talking about? How are we going to do this without the resources to do it? So I don't think the spirit of the act is bad at all. I think we do need those things. We need all the resources we can get for our kids, especially those kids that are so far down the line of endangerment that they're in group homes. The act was supposed to give us some more detailed guidelines by October 1st, but they have not come out yet. So we don't know the specifics of exactly what is going to be required. But we will certainly strive to do our best to do the best things possible for all our kids, even the older kids in group homes.
1 minute for rebuttal. You're on time. Good, thank you. Okay, the next question then goes to Helen. Guardians ad litem represent children in court. How will you evaluate who is appointed as a guardian ad litem and whether the GAL fulfills Supreme Court Rule 48 in serving in the child's best interest? And does the age of the child matter to your answer?
I don't think the age of the child matters to my answer because I think all children are important. I think a newborn baby is important, and I think a 17-year-old child is important. I can't say that one is less than the other. Supreme Court Rule 48 is highly detailed and specific in what guardian ad litems need to do. The problem is the guardian ad litems in our court, some of them are not doing what is required by Supreme Court Rule 48. We have guardian ad litems who are calling the children services caseworker the night before the hearing, or the probation officer the night before the hearing, not seeing the child. They come into court, openly admit they haven't seen the child, haven't observed the child in school or with foster parents, and that is terrible, and that should not be. If you vote me in as judge, I will institute processes and procedures again to make things better. Those guardian ad litems will not be on my appointed counsel list. I will ask for those guardian ad litems to be evaluated regularly. I don't know if that means twice a year or quarterly. We'll see how it goes, and of course, I'll talk to Judge Capizzi about it. But that's what needs to happen. The other thing that I think would be extremely helpful is having new guardian ad litems shadow some of our excellent, experienced guardian ad litems, like Julia Colbert, Jim Armstrong. You know, a lot of these things, like life, you can't learn until you've experienced them. So if they learn from the best that our court has to offer, they can do better. Sometimes they just don't know. So there are many things we can do to improve the situation. I look forward to having the opportunity to do so.
Yes, with guardian ad litems, again, as you guys heard from the beginning, it's been my passion all along, being a CASA from the start. One of the things, and I really, to be honest with you, I've talked with the Chief Justice, and I disagreed on Rule 48. Not that we need to have the rules set, not that you have to have these requirements. Now that's the no-brainer about Rule 48. But what happened with Rule 48, you got to have an attorney that's got 6 hours training, 3 hours every year. That's inadequate. I've always advocated that they need to take the CASA course. It's 36 hours, I believe, at this point. I've taken it twice. I've taken it every 10 years. Why? I need a refresher every once in a while. You need to get that spirit back in you to make sure that you are truly looking out for that best interest of that child. I think every guardian ad litem in our court in Montgomery County should take the CASA course. You shouldn't be on our list unless you've done that. You understand the law, but you need to understand the social work part of it. You need to understand the compassion that you need for these kids. And of course, there should be no age for these children. You know, I've gone to many houses. In fact, one of the guardian ad litem reports that when we do a training, they talk about, you should ask the child. Child's a couple of weeks old, you're meeting the child for the first time. Where do you want to live is one of the questions you ask. I included, you blew a bubble at me. Yeah. It's just those things that really, because one of the things, we're the ones that have contact with the kids. You've got to express what those children are doing, how they're doing in foster homes. I think our guardian ad litem list needs to be much more critical, and we need to be holding those, everybody that comes in front of my court, whether you're a children's services worker, you're a child, you're a parent, you're an attorney, and probably most important for me, if you're a guardian ad litem, you're going to be held accountable to the standards that we require you. And so I absolutely believe we should continue to work on this.
Jeff, may I respond?
I was just going to ask that question. Yeah.
Thank you. I have 2 children. I have a 15-year-old and a nearly 13-year-old. I don't need a refresher on what it means to be a guardian ad litem. I feel it in my bones. Those children that I am guardian ad litem for, I care about. I can't say as much as my own children because that probably wouldn't be honest, but I care about them as much as humanly possible because sometimes that's all that child has. The guardian ad litem is the only person in that child's life oftentimes that child can rely on. I have children calling me all the time. Still, I've done over a decade of guardian ad litem work. You are their person. And statistics show children just need one steady person in their life, even if they're in negative circumstances, to rely on, and they will be okay. So guardian ad litems need to fundamentally understand what they are undertaking before they agree to do it.
The next question is for Jeff. It is currently routine for children in Montgomery County to remain in foster care and unavailable for adoption. well beyond the 24 months stipulated in the Ohio Revised Code. What can the court do to rectify this injustice? And are there adequate regulations and procedures in place to balance reunification with the need for permanency?
And this is kind of a two-type-fold question. One, the question itself relies on that under our current statutes, it's 1 year that the child can be placed into foster care or out of home. It doesn't have to be foster care, but out of home. But the parents have the ability to really working towards reunification. You have 2 6-month extensions. So that's where I'm focusing the question on, because if you're talking about 24 months after permanent custody, that's a different question. But with regards to this, yeah, it's real simple. I've always asked the question as the guardian ad litem, because what will happen is you'll have the parent's attorney comes in, or children's services comes in and says, mom or dad has just done a couple things. They tested clean the last month, so we need a 6-month extension. Well, do you really need that 6-month extension, or are we just prolonging it? Did someone not do their job? Did the caseworker not follow through? Did the guardian ad litem, we just talked about guardian ad litem, did they not follow through? Okay? The 6-month extension is only there if it's necessary, and we need to continue to hold our magistrates, and as the judge, we need to continue to hold everybody accountable for that. You shouldn't be there getting 2 6-month extensions just because that's the next thing that we want to do. The other thing, though, that becomes difficult is you're trying to balance that family commitment as well as that permanency. And the problem is what we talked about with the very first question, the opioid addiction and epidemic. It takes 3 years for your brain to get back to where it was originally. So we have to do that. You have to balance that. But I don't believe you should be granting the additional 6-month extensions just because it's convenient for everybody and it's convenient for the attorneys on the case. So, I think we need to be held, everybody accountable to that, and including the court, and that's what I've already started to do in our court system.
Thank you. The court has recognized this problem. The court knows it takes too long. Judge Capizzi and Judge Kuntz worked on a new procedure that has been implemented in juvenile court. Judge Capizzi, on June 12th, changed the way extensions can be granted. No longer can a defense attorney or a guardian ad litem request an extension of temporary custody. That's not the way the statute reads. Statute allows for children's services to file a first extension if there's a significant reason to do so. The statute allows children's services to request a second extension of temporary custody only if there's a substantial reason for the change or the extension. So our court is now following that mandate. That will dramatically decrease the time that children are in the limbo period of being in foster care. And hopefully that will allow permanency in their lives a lot quicker. Now, there may still be reasons for an extension. If a parent is suddenly testing clean and doing well, that is a significant reason that Children's Services might request an extension of temporary custody. But it's not going to be the routine as it has been. I mean, routinely defense attorneys ask legal custody or in the alternative, first extension of temporary custody. That's been our practice. And the court has recognized that that is not in the best interest of the child. And Judge Kuntz and Judge Capizzi have made that change. So I think moving forward, we're going to see the results of that change. And if I am voted in, I will do everything I can to make cases move more efficiently. Thank you.